Maybe
Yes.
482 application, madam, costing of the proceeding.
Yes.
Well, there was an FIR, madam, and the petitioner, he was working as a DFO at that point of time in the state of Assam, Bihali range. An FIR was there that he, along with some police persons, around 100 of them, they dismantled a Baptist church and a rasputum. That is the allegation. Now, my lord, the cognizance charges have been filed. Thereafter, cognizance have been taken. The plea we have taken in this petition is that there was no prosecution sanction which was warranted in this case. As the petitioner, my lord, he was a DFO at that point of time, and under the instructions of the government, he dismantled this.
That means you want to say that while discharging his official duty, he.
My lord, exactly. That is precisely that point.
Was this point raised before the learned court below while framing the charge and all? Because
No, charges have not been filed.
not in faith. Okay.
Charges not yet been. That is one room of my argument, and the other matter is there is a meeting of the chief secretary level of both the states, Assam and Arunachal Pradesh. I have annexed the minus matter, and as per the minus matter, all the pending criminal cases lodged against the official of each other states matter, that has to be looked into by a different. If I may take your lordship for a moment, matter, page 46.
46.
6, 45, that starts. Right? This is the minus of the meeting, my lord. And if my lord comes to page 46, serial number 11. Serial 11. Withdrawal and closure of pending criminal cases registered against officials of one state by the other state in connection with previous border dispute incidents will be looked into by a committee consisting of the GP law and order of both the states for a settlement within 2 months. That is the procedure prescribed for the border disputes. That is my second room of my argument, madam. Now, if I may take your lordship to the FIR and all. Prior to that, if I may take your my lord to this provision. (72), man. 72. The state government may make rules consistent with the regulations. Now I'll take your lordship to C. To provide for ejectment of any person who has entered into unauthorized occupation in a forest reserve and for disposal of any crops raised or any building or other construction erected without authority in the forest reserves. So the state government, my lord, they can frame rules, my lord, rules and regulations. So under that power, my lord, this office memorandum has been issued in the year 2011. I'm taking your lordship to the second paragraph. All divisional forest officers are hereby instructed to undertake an immediate full-scale eviction exercise to free all reserve forests under their jurisdiction from encroachment as per the categories furnished below. Eviction of all encroachers who are liable to be evicted as per the provisions of the Recognition of Forest Rights Act 2005 and other relevant rules in force. Eviction of all encroachment that occurred after 13 December 2005. So under these provisions, the petitioner, my lord, went on getting the instruction that a rasputum and a Baptist church had been constructed in the forest land of Assam. Forest land of Assam. Therefore, he went and dismantled the Baptist church and the rasputum. Now, my lord, 197, my lord, is aware, my lord, that there is a bar in taking cognizance without the sanction, my lord. With the record, I'd like to rely on this judgment, my lord, on paragraph 13, your lordship, you will find at page 13. Page 13, paragraph 13. Ma'am. I'm sorry, page 12. Am I with your lordship, paragraph 13?
Yes, yes.
The second, the last paragraph, the legislative mandate. Am I with your lordship? Legislative mandate engrafted in subsection 1 of section 197 debarring a court from taking cognizance of offence except with a previous sanction of the government concerned in a case where the acts complained are of alleged to have been committed by a public servant in discharge of his official duty or purporting to be in discharge of his official duty, and such public servant is not removable from his office save by or with the sanction of the government touches the jurisdiction of the court itself. It is a prohibition imposed by the statute from taking cognizance the accused after appearing before the court on process being issued by an application indicating that the 197 is affected merely assists the court to rectify its error where jurisdiction has been exercised which it does not possess. In such a case, there should not be any bar for the accused from producing relevant documents and materials which will be ipso facto admissible. Well, if I may take your lawsuit to the last paragraph 9. Coming to the second question, it is now well settled by the Constitution Bench decision in this court, but in Masajot, that in the matter of grant of sanction under 197 of the Code of Criminal Procedure, the offence alleged to have been committed by the accused must have something to do or must be related in some manner with the discharge of official duty. In other words, there must be a reasonable connection between the act and the discharge of the official duty. The act must bear such relation to the duty that the accused could lay a reasonable claim, but not a pretended or a fanciful claim that he did it in the course of the performance of his duty. In the said case, it had been further held that where a power is conferred or a duty imposed by a statute or otherwise, and there is nothing said expressly inhibiting the exercise of the power or the performance of the duty by any limitation or restrictions, it is reasonable to hold that it carries with it the power of doing all such acts or employing such means as are reasonably necessary for the such execution, because it is a rule that when the law commands a thing to be done, it authorizes the performance of whatever may be necessary for the executing its command. Well, there has to be a relation between the act and the official duty. The official duty, my lord, I have placed before your lordship the official office memorandum, my lord, that says, my lord, all the DFOs are entitled for evicting the encroachers. So on receiving the information regarding the encroachment, the petitioner along with the police officials, he arrived at the place and found some encroachment. While trying to evict them, he had to dismantle the search and the restaurant. And the
Yes, it was a search over there. So have you issued any prior notice before dismantling the practice charge? Because it's an institution of some was there.
yeah, that is an omission of law or rule, my lord. But the fact remains, my lord, whatever has been done, it is in discharge of the official duty. Petitioner was discharging his official duty, my lord. And the office memorandum says the DFOs are entitled for evicting the encroachers that I have placed before a lawsuit.
Yes.
And that office memorandum has been issued as per Rule 72 of the Assam Forest Act, my lord. That provision also I have placed before your lawsuit. So, my lord, now only what lawsuit needs to see whether the act alleged is being done during the discharge of the official duty. And my other second leg of my argument is that regarding the border disputes, there is a procedure that I have placed before also the minors, and the PCF, the Principal Conservator of Forest, my lord, he have also written a letter to the government of Assam regarding this case that your lordship will find at page 43. This communication has been made by the Additional Principal Chief Conservator of Forest, my lord, to the Secretary of Government of Assam, Environment and Forest Department.
Hmm.
Records are also there, madam. I've checked up, madam. There is no document as regards sanction, madam. Records are available, scan copies, madam. This letter, madam, it says, madam, with reference to the subject cited above, I am directed to inform you that Sri Aniruddha De, the petitioner before your lordship, was posted as divisional forest officer in Sonitpur district. A building constructed illegally in Dikalmukh area of Bihar range forest under Borgang range was dismantled in his presence on 21/5/2013 in accordance with the relevant provisions of Assam Forest Regulation 1891. The construction site of the dismantled building was situated more than 2 kilometers from the south of the northern boundary of Bihali Range Forest, as evident from the square marks on the Google map images. Notably, the interstate boundary between the Assam and the Arunachal Pradesh are defined by the Northeastern Areas Recognition Act 1971, is conterminous to the northern boundary of Bihali Range Forest constituted in 1971, which is an integral part of the state of Assam. That area, my lord, itself falls under the state of Assam. And there has been encroachment from this side, my lord. So there was a direction, verbal, my lord, direction, and he has the power. It is not that he don't have the power. It has the power under this office memorandum. He evicted the encroachers. Continuing that, my lord, the
The
interstate,
eviction was only verbal.
my lord,
The eviction was only verbal.
information was received by the government of Assam regarding the encroachment, and he was asked to go and evict the encroachers. And he has the power. The office memorandum I have placed, my lord, that comes under his official duties, evicting the encroachers. Eviction of encroachers are the duties of a divisional forest officer. The office memorandum says so. The interstate boundary dispute raised by the Arunachal Pradesh remain in unresolved issue for more than 5 decades. The miscellaneous case so on the interstate dispute filed in the Honorable Supreme Court of India is also pending without any amicable solution to that problem. However, in pursuance of the agreement reached in a meeting between the Honorable Chief Minister of both the sides in 1979, status quo was maintained and the occupants from the Arunachal Pradesh in Dikalmukh were not disturbed. The construction of the building beyond the southern limit of their occupied area was a blatant attempt to extend the area of occupation, which needed to be dismantled in the interest of forest protection and to maintain the territorial integrity of the state. Paragraph, page 44, the second paragraph. It is pertinent to mention. It is pertinent to mention that a chief secretary level meeting was held on 12/10/2020 in Itanagar, and a decision was taken for and closure of pending criminal cases registered against the officials of one state by the other in connection with the previous border disputes incidents after being looked into by a committee consisting of the IGPs, law and order of both the states for settlement within 2 months. That these minors I have taken to your lawsuit. So, I have only two leg of argument. The first, the sanction, the cognizance has been taken without previous sanction, and the second is these minors. If there are disputes regarding the borders, then it has to go to the IGPs of both the states. They will take it call, minor. Not that you go and file an FIR or something like that. Well, I pray that the proceeding against the petitioner may be quashed, my lord. And alternatively, if this option is also there before the prosecution, that they may approach the IGPs. This is the minus, what the minus says, my lord. It's not that if the proceeding is quashed, the petitioner will be skip free. There is a procedure for that purpose also. That may be taken into consideration. The judgment that I have referred, Malak, there is, in that judgment, a judgment has been relied of Gauri Shankar Prasad, page 14. It is manifest. It is manifest that the appellant was present at the place of occurrence in his official capacity as subdivisional magistrate for the purpose of removal of encroachment from the government land, and in exercise of such duty, he is alleged to have committed the acts which form the gravamen of the allegation contained in the complaint lodged by the respondent. In such circumstances, it cannot be held that the acts complained of by the respondent against the appellant have a reasonable nexus with the official duty of the appellant. It follows, therefore, that the appellant is entitled to the immunity from the criminal proceeding without sanction provided under section 197. The facts also somehow relates to the present case.
May it please, Your Lordship. With regard to sanction, I do have an judgment, Your Lordship. 197, when does it come? Does it come for a regular sections in IPC, or will it be only with regard to PC Act, Your Lordship? If I may take Your Lordship to the second last page, Your Lordship. While discussing the entire case on 197, where would it be invoked either under IPC or PC Act, Your Lordship, will come to paragraph 58, Your Lordship. Second last page.
58.
Yes. If I may read, Your Lordship. Thus, although in present case, the appellant has been discharged from the offence under the PC Act 1988, yet for the IPC offence, he can be proceeded further in accordance with law. From the aforesaid, it can be said that there can be no term rule that in prosecution before the court of special judge, the previous sanction under section 19 of the PC Act 1988 would invariably be the only prerequisite. If the offences on the charge of which the public servant is expected to be put on trial includes the offence other than those punishable under the PC Act 1988, that is to say the general law IPC, the court is bound to examine at the time of cognizance and also if necessary at subsequent stage as the case progress as to whether there is necessity of sanction under section 197 of CRPC. There is a material difference between the statutory requirement of section 19 of PC Act 1988 on one hand and section 197 of CRPC on the other hand. In prosecution for offence exclusively under PC Act 1988, sanction is mandatory qua the public servant. In cases under the general penal law against the public servant, the necessity of sanction under 197 of CRPC depends on the factual aspect. The test in later cases of nexus between the act of commission or omission and the official duty of the public servant. To commit an offence punishable under law, can there be a part of official duty of a public servant? It is too simplistic an approach to adopt and to reject the necessity of section under 197 on such reasoning. The safe and sure test is to ascertain if the omission or neglect to commit the act complained of such would have made the public servant answerable for the charge of dereliction of his official duty. He may have acted in excess of his duty, but if there is a reasonable connection between the impugned act and the performance of the official duty, the protective umbrella of section 197 cannot be denied so as long as the discharge. Now your lordship will see that there has to be, though there might be an omission, there has to be a reason for that, your lordship. Now, if your lordship comes to the office notification that they have submitted, your lordship, of the year 2011,
Yes.
Your Lordship will see it's from the state of Assam, firstly. Secondly, the DFO though was instructed for immediate eviction, Your Lordship. How is then eviction to be done? It shall be done under the Forest Right Act of 2005 and the relevant rules. Last paragraph, assistance from civil and police authority may be obtained if necessary. Conservators of forest concerns are requested to closely monitor the eviction operation. Chief Conservator of Forest are requested to supervise the eviction exercise on regular basis. Now, Your Lordship will see in Assam Eviction Act, there is a mandatory section where it says that prior to an eviction, there has to be a they should analyze if there is any demarcation, Your Lordship. Secondly, there should be a notice prior to eviction. And thirdly, Your Lordship is well aware, even this office notification states that it should be under the observation of CCF, Your Lordship, Chief Conservator of Forest, Lordship. Now, how did this eviction so happen? Your Lordship will come to page number 22, the statement of the accused. Page number 22. 22. If I may read, Your Lordship. I'm a permanent resident of above noted address and presently I'm employed as DFO, Sonitpur, so-and-so at Biswanath Charity. On 14/5/13, I got an information from my staff. Your Lordship will see my staff that some permanent structure is coming up. One is a rostrum and another is a under construction building in notified area or preserve forest, Behil under Assam territory. Accordingly, I discussed the matter with higher officials and district administration, to which they directed me to evict the same. Your Lordship will see there is no only verbal instruction, Your Lordship. Accordingly, on 21/5/2013, that is after 5 days, Your Lordship, I called my field official, range forest officer, RFO, so-and-so, another fourth line staff and Assam Forest Protection Force and briefed them to go for eviction. Now he have directed for eviction as per the direction of DC Sonitpur and our higher official. Before this, I already discussed with PCCF, who also directed me to go ahead. There were 3 sections of Assam Forest Protection Force, including 30 other regular staff. We have used 5 vehicles, but we left the vehicles on the way. As the road condition was not good, we travel on foot about 1.5 kilometers. We have used 1 JCB for eviction purpose and started eviction and demolishing on 21/5/2013 at 8:30 a.m. And accordingly, the permanent structure, approximately 500 square feet on 1613 and Rustam appearing to be 8 by 8 feet, was demolished within 1.5 hours by 9:30. The demolition of evictions was completed and went back. From Borang Range Forest, we dispersed. Subsequently, I intimated to DC Sonitpur, Conservator of Forest, Tejpur, CCF, PCCF, Guwahati, and they appreciated my job. No more to say. Now, the question put to him was, as per the statement of the complainant and witness, some of your men were in civil dress during eviction and demolition of church. Who were those persons? They were she so-and-so, so-and-so, from Forest Protection Force, who are my subordinate officer. Under whose direction, Your Lordship will say, under whose direction and order in black and white you made the eviction and demolition? He answers, I did it under the provision of Assam Forest Regulation 1972. Assam, there is no 1972, Your Lordship. It's 1891, Your Lordship is well aware. He himself said there was under whose instruction? Only under this proviso, he has made his eviction. Now, when Your Lordship will look at to Code 1, we also have this Assam Forest Regulation Act, Your Lordship, at page number 6. Here, Your Lordship. There is no procedure as to how a person has to be evicted, Your Lordship. There is only provision. No, Assam. Page number 6, Your Lordship. Oh, yeah. It's me. There is no proviso as to how the eviction has to be taken place. If there has to be any eviction, for any person who illegally enter or occupy any forest land, there is a process of how the penalties for such uh, encroachment, Your Lordship. How is there is no section as with regard to eviction, Your Lordship. Thus, there are provision even for seizure of the products, but not for demolition. Your Lordship is now under which provision he says is under the Assam Forest Regulation Act of 19. Next answer, next question, Your Lordship will see why you did not feel necessary to give notice to the occupant of or the constructors. His answer is under Forest Act it does not require. Next, Your Lordship, the demolition made by you is totally falls under the territory of Arunachal and appears that you have violated the order of Supreme Court, who already directed to maintain the status quo. What would you say? He says, presently I do not have any document proof with me. However, it is lying in my office. He does not. He comes there for eviction without any documentary proof, Your Lordship. As per the statement of witnesses and the complainant, you people have deleted the photo taken by the public. That's not relevant, Your Lordship. Last question, Your Lordship. As per the statement of victim, Assam police were also with you during eviction and demolition of church and Rustam. Is it true? No, Assam police did not accompany me except our office protection force and regular staff. The uniform of our personals are also like uniform of police, hence public might have misunderstood. Now, this is his own statement without any documents of demarcation, without any proof. He comes and evict without any instruction, Your Lordship. Now, if Your Lordship will come to the statement at page number 24, Your Lordship, the next page. One of the complainant's statement. On examination, he states that on 21/5/2013 at about 8:45 hours, Assam police along with forest officials numbering about 100 visited our village and demolished our Baptist church and public Rustam despite our protest not to demolish the same. But I could not able to identify any of the police and forest personnel. The cost of church Rustam is rupees 6 lakh. This church was established, Your Lordship will see, this church was established in the year 1983. This demolished church was completed in the month of April 23 with an intention to demolish the old church. The Rustam was completed in the year 2008. So during the entire such period, there were no complaints. Suddenly one day, Your Lordship will see on 14, he gets a complaint. On 14, he, as per his statement, he makes a telephonic call to all the chief officer and they let him go. They make a signal of go for demolition, Your Lordship. After 5 days, without any written instruction, he on 21/5/2013, he comes and evict the entire and demolish the entire Rustam as well as the church. Now, if I may take Your Lordship to page number 30. This is the statement of one of the complainant. My only intention to show this is that he was the one who had identified the accused here in Your Lordship. Now, as they have pointed out, Your Lordship will see that at page number 43. Your Lordship, at page number. This is of the year 4th of June 2021. Your Lordship will see this letter was made by additional PCCF to Assam to PCCF Assam, Your Lordship. There is no reference to the state as such. Only on the next page, there is a reference that there was a meeting held, Your Lordship. Since I have already read, Your Lordship, I won't go through the same, Your Lordship. However, Your Lordship will see that there is only a reference to quashing of this particular case, Your Lordship. Now, if I may take Your Lordship to page number 47, Your Lordship. Page number 47 is an application to the PCCF Assam by the accused himself when he was promoted to DCF for quashing of this case, Your Lordship. The next application he made was at page number 50. This is of the August 2023, Your Lordship. This was also made by the applicant himself to the PCCF Assam, Your Lordship. Now, if I may take Your Lordship to page number 45, which is the minute. Your Lordship will see that both the state already have a boundary issue, and both the states are jointly are in the process of settling these boundary issues, Your Lordship. Meanwhile, Your Lordship will then come to page number 43 again, Your Lordship. The second paragraph, Your Lordship will see the Honorable Chief Minister, if I may read the second paragraph, Your Lordship. The interstate boundary dispute raised by Arunachal Pradesh is while NEFA remains in unsolved issue for more than 5 decades. The missed case so-and-so on interstate dispute filed in the Honorable Supreme Court of India is also pending without any amicable solution to the vexed problem. However, the in pursuance of the agreement approach in between the Honorable Chief Minister of both the sides in 1979, status quo was maintained. Now, when 1979, when the status quo was maintained, Your Lordship, subsequent thereto, when the charge was made in the year 1983, Your Lordship. Your Lordship will see that there was this case is still pending, Your Lordship, where the status quo of both the parties to be mentioned. Now, this letter where the additional PCCF state before the PCCF that he was discharging his duty, Your Lordship. However, he does not disclose that if any prior notice was made, if there was any document to prove that they have gone beyond what was the status quo demarcation, Your Lordship. Nothing is such. Even the statement of the accused himself is very clear that he has done it only on, Your Lordship will see, mark the date. He got the information on 14th. He has discussed it with his superior higher officials, Your Lordship. However, since from 14 till 21, there is no written instruction given to him for eviction, Your Lordship. He goes forward with his own motive, Your Lordship. There is no order as such for eviction. He goes by there by himself. He takes along people with him and then do the go with the process of eviction and demolition, Your Lordship. Now, under 197, Your Lordship, the court is only to analyze if he was doing his duty or was he discharging his duty, Your Lordship. Therefore, he has full authority with regard to the forest, Your Lordship. However, with the circumstances in this case, Your Lordship, that there is already a tension between both the borders with regard to demarcation of boundaries, Your Lordship. Was there any order asking him to go for eviction? Was there any order with regard to demolition of this place, Your Lordship? Did he have any documents to make it clear that the demarcation, Your Lordship, as per the status quo, did the construction or any encroachment was beyond that status quo order, Your Lordship? That it's his statement itself makes it very clear, Your Lordship. With that, I clearly find that he was not discharging his duty under 197, Your Lordship. Also, Your Lordship, the office memorandum, if whatsoever, Your Lordship, 2011, that they have submitted, Your Lordship, it clearly says that he should be under the entire eviction exercise has to be under the observation and with regard supervision of the CCF, Your Lordship, which is also very clearly not complied in this during his process of eviction.
That to the communications made by the petitioner to the government of Assam was just to inform or bring to the notice that there is a border dispute and then has to be taken care of by the IJPs of both the states. That for that reason, those representations were made. And regarding the statement under 161, if my lord is taking note of that, then it is itself from that it is clear that he was instructed. Well, there may not be any written instruction, but any omission or commission which postulates an act should be purportedly to be in discharge of his duty. There has been an omission in the sense like that there was no written instructions. That is an omission. And the commission is that he went on and did the dismantlation. So that is the commission. Now, Lordship has to see whether this omission and commission of the offense alleged were being done during the discharge of his official duty or not. That is the only simple question to be considered. Now, as per the Rule 72, the state government has the power to frame laws. That office memorandum is under 72. And that gives the power to the DFOs for dismantlation of encroachments. That is my humble opinion. Only thing to be looked at whether the commission or omission was in discharge of his official duty. He was a direct DFO at that point of time. And under the instructions of his senior officer, which is apparent from the 161 statement of the accused. If my lord is taking consideration of the 161 statement.
Yes, since the charge has not been framed.
Order do I have to reserve because I
Yes.
have shortage of time
Yes.
problem today.
Right.
If not from here, definitely from Guwahati, I will
Fine.
deliver it.
Records are there. I checked up the records, my lord. I could not find the sanction.
Sanction.
Your Lordship, also with in that case of sanction, Your Lordship, supposedly it's to be given, Your Lordship. Even during the framing of charges, Your Lordship, the court can call for and stay the date for framing of the charge. Also, Your Lordship, that I have also shown, Your Lordship, the application of the later application 2021 and 23 of the accused, Your Lordship. Even in his application, there is no part where he give us any with regard to if there was an omission or commission, Your Lordship. That is also very clear. Otherwise, that part could have been very clearly made by him that such was an omission, which is deliberate or which is not.
No, with regard to the submission that during the charge framing of charge, this point can be taken up.
Sanction.
Sanction point can be taken up at the stage of framing of charge. With regard to that of that same judgment, my lord, I'm reading one line, my lord. It is well settled that an application under section 482 of the criminal procedure is maintainable to quash the proceedings which are expressly bad or bad for want of sanction. And it can be agitated at any moment, not that at the end, it comes to an end, you cannot or at the very initial stage, you cannot, at any stage, during the pendency of the trial also, after framing of charge, that issue can be taken up before any higher forum. That is what the law says. It is not that you have to do it at the framing of charge.
Very
And
initial.
at any stage it can become. And judgment I'm relying is of a 3 judges benchman.
Yes. See.
My lord is keeping the book, man. If required,
Book, it's your book. You
Yes.
can take it. Yes, you go. Your
If
book.
you want,
We
if you
have,
lordship,
no, we have. I thought it's our book.
oblige.
It is in order column, why?
Your Lordship, last order was fixed for admission hearing today.
Uh-huh.
As for last order, the matter was fixed today for admission hearing. Though it is reflected in the cause list, in the order stage, Your Lordship.
Not in a position to hear the matter today.
Oh,
So it will be again in admission column only. Her Mr., your Mr.
I'm Mr. K. Tagyang.
For the petitioner. He died from the petitioner.
Yes, I'm petitioner.
So her Arsona
Beniables.
Huh?
Beniables on behalf of Arsana.
on behalf of Arsona so and so. And also her, you also.
Yes, I'm for respondent number 3, Your Lordship. We have filed our counter affidavit.
You want to file your?
No, we have already filed our counter affidavit.
You're appealing for respondent number 3.
Yes, Your Lordship.
Also her so and so appealing for respondent number 2. And she submitted that they have already filed their evidence on affidavit. Evidence in opposition, affidavit in opposition. And you also appealing? For respondent number 2. Respondent number 2. Have you filed your affidavit in opposition? Not yet. You want to file? Okay then, also have so and so appearing on, for whom you have appeared? Appeared on behalf of the council for respondent number 2. State, for state.
Yes, Your Lordship.
This is the matter accordingly in the admission column. On, if you want any fix that I can give.
Yes, Your Lordship, since I'm coming from the state, I may be
From-
given a fixed
from
date
where?
on 15th of February.
From where you have come?
I'm coming from Zero.
Acha, 0.
Yes.
On 15th?
Yes, on 15th February.
You
16th
say
February.
15th?
17 or 19.
15.
Okay.
16th?
19.
19.
Yes.
Your Lordship, there may be order to continue the interim.
Interim was there.
Yes.
Interim will continue till next date of this. Okay.
Deeply obliged. my lord.
Yes, sir, was Your Lordship.
Item number 6, there are one.
Four items, my lord. 4 IAs.
4 IAs.
IAs.
What are those
First,
IAs?
first to IA for continuation of delay in filing the review petition. my lord.
All the IAs are.
All the IAs. There are 4 review petitions. Against the 4 review petitions, 4 IAs are there.
I guess 4 revision petition, 4 IAs are there.
IA are there. So with regard to IA number 93 of 2023 and 94 of 2023, service has been completed and the other side has appeared private respondent. And so far as IA number 95 and IA number 96, service is still awaited as per the office note. So my lord, we will wait for another 1 month and thereafter if it is, they doesn't appear, then we will take
For-
it.
In regards to 93, it is already completed.
93 is already completed. 94 is also already completed.
93 and 94 are already completed.
Already completed.
So is there any objection or affidavit in opposition?
They have not filed objection. They most probably they will advance their oral argument.
You are appearing in all.
Yes, Your Lordship, on behalf of T party for respondent number 1.
On behalf
On-
of Tea
on
Party,
the
you have
IA.
appeared for respondent number 1.
Yes,
How many
sir.
respondents are there in fact?
There
all
are
cases.
other respondent are government of Arunachal Pradesh.
You are appearing.
Yes, I'm for respondent number 4, 5, and 6, Your Lordship.
4, 5 and 6. Hmm? You are one.
Yes, your lordship.
You're 3, 4, and 5. Huh? 4, 5, and 6. Yes, 4, 5, and 6. But 4, 5, and 6, but 2 and 3. Ministry of Consumer Affairs. For them, someone is appearing? No. So you are not appearing for 2 and 3? 4, 5, and 6. As per the office note, all the Karatnama has been filed on. Office note is not available in regards to the service of
2 and 3.
notices. Oh, right, right, one.
Assistant to the Solicitor General will appear. Yes. The government of India. They are.
Your lordship, 93, 94, 2 and 3, your lordship. Your lordship, 4, 5, and 6. Lordship, 2 and 3, your lordship. You are for 2 and 3. Yes, sir, that's it. State of ownership by the Secretary of Government.
No, 2 and 3 is Secretary to the government.
No, I also.
93.
We are on 93. See, check 93. 93, most probably you are for 4, 5, and 6. Those review petition are not being admitted most probably. Yes,
Yes.
4, 5, and 6. 93, 4, 5, and 6. Yes, sir, that's it.
Do you know about anything about 2 and 3? They are going to appear on
Mr.
from
Kato,
where
they
you
are
have stated that the notices are already being served on all the respondents.
we have served to the government advocate, Mr. Kato. We will talk to him we'll request him to appear on the next date for 2 and 3 in item number 1.
So can I record your submission that
Ye-
the
ye-
notice
yes,
has
ma'am.
already been served?
Yes, my lord.
In 93, heard Mr. B.K. Singh, the learned counsel for the applicant, and also heard. You are for Tea Party.
Yes, your
Your
lordship.
good name?
E. Payang.
E. Buying, the learned counsel appearing on behalf of the NBS counsel, Mr. Tea Party. And we also heard MS so the government advocate. You are not appearing? I am in I number 94. You are on 94. Appearing on behalf of government advocate, appearing on behalf of 4, 5, and 6. However, it is submitted by the learned counsel for the applicant, applicant that the notices are already being served through the learned, whom you have sent?
I think it was to Mr. Kato.
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 Is
We
he-
will again serve.
No, Mr. Kato is.
For he is Assistant Solicitor General of
Assistant
India,
Solicitor
so
General.
he is
Assistant
representing
Solicitor
Government of
General.
India.
Served, deputy, served to Mr. M. Kato, the Deputy Solicitor General, However,
Then it can be
6th of March.
6th of March. All the matters?
All the matters.
And come to 94.
94, the respondent are only that private respondent is appearing and the government of Arunachal Pradesh is represented by.
2 and 3. You are 2 and 3.
Yes, sir.
Baaki same থাকিব, representative, government advocate is representing the 2 and 3, and 1 is represented by so and so on behalf of Tea Party, and Mr. Singh is there. So services completed. Huh? Oh, you are on, in 94, you are for 1?
Yes, one.
Oh, BP cha, huh? This is matter accordingly on 6th of March. That's accordingly, it's in the services completed, this is March, 6th of March. And 95,
5.
95, same or 95?
Service is awaiting as far as respondent number 1 is concerned.
In
We'll
both
wait for
90,
another
95 and 96.
95 and 96.
How many respondents are here? in
The
this?
3
95?
1, 2, 3, 4 respondents.
Out of 4 is the government side is appearing? Yes, 2 and 3 out of 4. 2 and 3. 4 is again?
Mother, actually that numbering is wrong. 2, 3 and 4.
2, 3 and 4. You are
Two
appealing
has
for
been
2,
repeated.
3 and 4, I think.
Yes, yes.
2, 3 and 4, okay. 2, 3 and 4 government আছে. 1 is awaited. As per office note. Just let me see. As per office note dated 1/2/2024, the service is still awaited for respondent number 1. That will be listed on 6th of, service be awaited till next set of listing. Listing matter on 6/3/2000. And for 96, you are appearing? In 96, again, in 96, 2, 3 and 4. 1 is still awaited,
Still.
same order. All will be matter will be 6th and
6th of March. Obliged.
Obliged.
मेरा लिख दिया application. हाँ लिखा हुआ. 6 March ना. Thank you.
मेरा नाम यहाँ है मैडम हाँ हाँ